was just recently amended. In fact, we just got one additional amendment change that I've included. And this is June 12th. And I think yesterday also there was something, but it's already been included. So let me look at this in the state's requested instructions. I think that you had included the amended instruction.
That's correct, Your Honor.
So I would request that the court include language from the 11th Circuit U.S. Court of Appeals pattern instruction. See, one moment, Your Honor.
Okay.
Forgive me, Your Honor, just one more second.
Okay.
So the 11th Circuit U.S. Court of Appeals instruction says proof beyond a reasonable doubt is proof so convincing that you would be willing to rely and act on it without hesitation in the most important of your own affairs. I would ask that that language be included in the instructions to this jury.
Okay. You have any comment?
This has been kind of laborious, so I'll just make a little half-hearted joke that maybe Mr. Shrevenick got off at the wrong exit, because we're to the west of I-95, not to the east in the federal courthouse building. But I mean, as much as just as recently as last week, we've been given a new reasonable doubt instruction to be used in all Florida criminal cases. I don't see us bringing in the federal standard for a case like this.
I'm going to decline the request, but you might want to type that up also, and if you can mark it and include it in part of the record as well.
I think we have a court reporter who
That's fine.
heard what I said, but
Okay.
and she's nodding, so I think we're good, and I can just tell the court it's easily attainable at the 11th Circuit pattern jury instruction.
That's fine. Oh. Then we're going to get to weighing the evidence. And again, this as part of the standard, I took out, let's see, let me see, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Number 2. Number 3, was the witness honest and straightforward in answering the attorney's questions? Number 4, did the witness have some interest in how the case should be decided? Number 5, does the witness's testimony agree with the other testimony and other evidence in the case? Number 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
The state wants that in. It looks like the defense wants it.
Sorry?
The state wants that instruction to be included. It looks like the defense does not.
I'm not sure it has any application. I don't see what the application is to this case. I think that's typically when you have a cooperating witness, you know? Like a prisoner who's...
We have a witness that was offered money.
Sorry?
We did have a witness that testified for the defense that was offered money, so I think that that should be a factor that the jury can take into account.
Okay.
So that's why I'm asking for that instruction to be included.
Well, didn't you have a paid expert?
Yeah, both sides did.
Okay. I understand what the defense is saying in the context of more of like a cooperating witness. Over objection, I'm going to give number 6. And did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? I'm going to give that. I think that's it. And I'm going to, I'll give the expert witness instruction. I don't see any changes in terms of, from the language of the standard.
I'm sorry, where are we now?
Page,
Expert
I've
witness?
just finished the, I finished number 7, and I renumbered them. And then whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. Okay. Then I move down to the law enforcement witnesses. Were there any female law enforcement witnesses that testified? Because it says his or her, so I'm just asking.
Oh, we can take out the her.
Okay. Expert witnesses, I'm going to give that instruction. And let's see, his or her opinion. Didn't we have female expert?
Yes.
Okay, so it would be his or her. And the next paragraph, it's okay for a lawyer to talk to a witness. I don't see any changes there. And the last paragraph, there's been no changes there. So we'll leave that. Then the next instruction is defendant not testifying. Do you want both paragraphs?
Judge, I would ask that in the second paragraph, second to last line, after the name George Pino, two words, did or, should be removed because in this case, Mr. Pino did not take the witness stand. So the last sentence would read.
Oh, I see what you're saying, okay.
No problem, Judge, we agree.
Okay. Okay. You're also asking that I put your client's name where it says defendant.
It's fine, as you wish.
Any objection from the state? I would say against the defendant, George Pino.
Well, in the other places in the instructions where it called for us to use his name rather than the defendant,
Right.
it's listed in the
There's
same
a
way that it's
bracketed-
charged in the information. So
Yeah.
it'd be George I. Pino.
Yeah. So it's highlighted in the other standard instructions that you should actually put the specific name. But in this instruction,
It does not.
3.9, just so we're clear, and let me double check that.
If you look at this standard, it doesn't ask for the
Yeah,
defendant's
okay.
name in the way that it does like for the statement of the charge.
Right. All right, I'm gonna just, on the first sentence, just say defendant George Pino, then the rest of it will be the defendant. Put his name there, okay? Look at the next instruction, which is defendant's statements.
One moment, Your Honor.
I think that's the standard, and I think you agree with the standard from what I'm reading in your requested instructions.
Yes, Judge, I'm trying to process one other issue. 1 second.
Okay. Melissa, you okay? You need a break? You want to take a minute?
We're almost done, right?
I think we are, but you want it, you need a,
I'm sorry. We're almost done. I'm good.
okay, whatever, okay.
Your Honor, we have a request that in proposed instruction 3.9B Bravo, defendant's statement.
3.9B,
Is that what it is? So mine says, yeah.
defendant's statements, yes, okay.
In the middle of the page, it has 2 factors to consider.
Yes,
We would propose a third one, and that is Mr. Pino's mental and physical condition at the time of the statement.
Your Honor, the state would object to that. The purpose of 3.9B is to ensure that the statement was freely and voluntarily made, not that it was also necessarily intelligently made,
okay.
or that it was made by a person, you know, that had a particular physical condition or non-condition. It talks about to make sure that it was freely and voluntarily made. That's the issue. There's no
Okay,
allegation.
part of the
here.
argument,
They can argue.
part of your argument is going to be it wasn't freely or voluntarily made because Mr. Pino was suffering the effects of a medical event, a concussion, or right? Okay. The instruction says, though, whether they were freely and voluntarily made. So, including but not limited to. So, I am going to decline your request. But certainly that's goes into the argument of whether it was freely or voluntarily made. And other things that, you know, and you know, this is in the context of where you see these instructions is when there is a statement against interest, when there's a confession, when there's, so, yeah, I'm not going to add a third paragraph to the standard, but that'll be part of your argument as to why it was not freely and voluntarily made. Okay. Look at rules for deliberation. And I think we agree that since this is not a penalty phase, a capital case, that there were certain paragraphs that are taken out. Everything else, what I'm reading from the defense version and the state version look to be consistent.
Agreed, Your Honor.
And there are seven paragraphs that the jury should consider in the rules for deliberation. Let me know when you're ready.
I'm ready.
Okay. Cautionary instruction. I think it's consistent with the state and the defense with the standard instruction, and nothing, there were no special requested instructions. Verdict.
I'm not sure I understand.
There's no lesser, so that first paragraph, it is out on what would have been the standard, because I'm not instructing them on any lesser, so I'm going to take that paragraph. That was in your draft.
Yes, but
All right, then I have the verdict form, which I'll go over in a minute. Let's just keep finishing up with the instructions here.
with regard to the verdict instruction,
Yes.
you have under consideration the issue that we raised earlier about that if the jury were to find Mr. Pino not guilty of vessel homicide, that would necessarily end the deliberations, because vessel homicide is the lesser offense than manslaughter. So you still have that under consideration.
Right, so, and I think that if there's going to be, if I'm going to make any changes or amendments to the standard, it would be at this point, because I still haven't decided that yet. Okay? Okay.
And so the request for the, what I'll call the special verdict form regarding not having the jury deliberate on manslaughter if the jury has found that Mr. Pino is not guilty of vessel homicide. That would then affect what is now, I think, 3.12A alpha, single defendant, multiple count of informations.
Yes. I see, yes, I agree. If I'm going to add any language, it would impact that as well.
And then you'll see our next proposed instruction, 3.12D delta, legally interlocking counts.
Okay. All right. Steve, have you had a chance at all, because I don't know if you have, to look at the request on the 3.12 legally interlocking counts?
Yes, and it's not a correct statement of the law for a variety of reasons. First of all, even if the jury finds the defendant not guilty of vessel homicide, they still could find him guilty of manslaughter because, number one, they are not considered truly inconsistent under the Perez case, and number two, the state has charged the defendant with manslaughter under both the culpable negligence and intentional act theory. So telling the jury that they cannot find the defendant guilty of the crime of manslaughter if he is found not guilty of vehicular homicide is an inaccurate statement of the law.
Okay, so this actually then boils down to, when we go back to how the state charged the manslaughter with alternative theories.
I don't agree. I think whether it's alternative A or B, the state cannot achieve a manslaughter conviction if the jury finds that the defendant was not guilty of vessel homicide, because a finding of not guilty on vessel homicide is that the defendant did not act recklessly, much less culpably negligent, much less intentionally.
Your Honor, I know that only in today's discussion about the jury instructions have I made reference to the State versus Perez case, but I think if we, just even broke for 5 minutes, it's very, short opinion, but there the defendant was charged both with reckless driving and vehicular homicide. The jury found not guilty of reckless driving, found him guilty of vehicular homicide. So the defense said, well, if the jury said he wasn't driving recklessly, then how can it be vehicular homicide? And the court said that we would conclude that the doctrine of lenity or of jury pardon should apply. There was abundant evidence to support the conviction of vehicular homicide as discussed above. Had the jury been instructed that reckless driving was a lesser included offense homicide, as perhaps it should have been, the result would have been the same, guilty of the greater charge. In this case, it appears that the jury may have analyzed the problem of overlapping charges better than the defense, prosecution, and the judge, and it dealt with it by finding him not guilty of the lesser, but may have sought to punish him twice for essentially the same series of acts. So in this particular case, where the state has charged two separate offenses, rather than charging one and relying on the second as a lesser, the jury should be able to make their own findings as to each charge. And if ultimately, if the jury were to come back guilty on both, okay, then maybe we won't have a double jeopardy issue. If they come back guilty on manslaughter but not on vehicular homicide, I would cite to the Perez case saying it's not an inconsistent verdict. If they came back guilty on vessel homicide but not guilty on manslaughter, okay, and obviously if they come back not guilty on everything, we got nothing to discuss.
Do you think that this should be a special verdict as to either theory on manslaughter?
No.
Okay.
Because just like you don't have to have a special verdict on first degree murder if it's premeditated or felony murder.
Yeah.
However you want to slice it, the jurors can half and half find, there's no basis for a special verdict. This isn't like, oh, we're going to get an enhancement if there's a firearm or something like that.
Okay. Okay. Now, what was that? Give me the citation.
Of course, Your Honor. It's State versus Perez, 718, Southern 2nd, 912. It is a 5th District Court of Appeal case from 1998.
Okay.
Judge, if we can respond to that case.
Go ahead.
So in Perez, the two charges were vehicular homicide and reckless driving, which reckless driving had no death component to it. So the difference between that case and this case is the driver in Perez committed a series of acts which could have been considered by the jury to have been reckless. And the court said the jury, and I'll read the quote to you, in this case, the jury could have concluded that Perez's decision to speed and pass cars in a no passing zone was not reckless, which is why, as to reckless driving, no death resulted from that action. The jury could have acquitted him. But his final decision, the one that did cause death, to try to pass the last car after seeing the approaching van, was reckless. So it wasn't a truly inconsistent verdict, whereas in Mr. Pino's case, both manslaughter, the culpable negligence component of that, and the intentional act component of that, as well as vessel homicide, must be an action that results in death. So if the jury finds Mr. Pino was not reckless, and therefore his quote-unquote reckless conduct did not cause death, they necessarily are finding that a higher mens rea did not cause death. It's different. It's not as if he's charged with manslaughter on count 1 and culpable negligence generally on count 2, whereas they could find, an action of his along the way was or was not culpable negligence, but did not cause death. Does that make sense?
Makes sense what you're saying. I hear it. I understand that.
Right.
Well, first of all, the appellate court is hypothesizing what that particular jury may have done, that they could have said, well, we're going to give him a pass, so to speak, for some conduct, but not for others. But either way, the court right there is just kind of speculating on what the jury would have done, but they recognize that regardless of what the reason was, it could have been a doctrine of lenity or it could have been a jury pardon. It could have been any of those things. And the appellate court still said it's not an inconsistent verdict.
But it under the manslaughter resulting in death, under either theory.
Yes, and that's the other reason why this case assures us that there's no reason for the court to instruct the jury. You cannot find him guilty of manslaughter if you don't find him guilty of of vessel homicide. That there's no basis in the law to instruct the jury that way. Manslaughter we can prove by culpable negligence and or intentional act. Vessel homicide is only with recklessness, and even if reckless is somewhat of a lesser of culpable negligence, reckless driving is a lesser of vehicular homicide. Yet in this Perez case, when the jury came back not guilty on reckless driving, but guilty on vehicular homicide, the court said that's not an inconsistent verdict.
Two important points. One is that the Supreme Court of Florida has specifically said in McCreary, the legislator intended and did create a lesser included offense with a lesser standard of proof required for conviction. There's no doubt the Supreme Court has said that. That's how they've upheld this distinction between the two statutes. Second, in Perez, there was a theory of consistency, and that is that he may have been reckless at one moment in time, not causing death. He may have been reckless at another moment in time, actually causing death. And the jury could evaluate the two scenarios independently. More importantly, the Court of Appeals seemed to say it wouldn't matter anyway, because on appeal, standard of review, we assume the jury acted out of lenity, not logically. Going forward, though, looking prospectively, the court should be trying to make sure the jury does act logically. And to say that it's okay, let's send it in there and we'll let the Court of Appeals justify an illogical outcome seems to be a result-oriented approach that is not what the law should be.
No, but isn't it because there are both theories that the state operates under in making an argument, okay? If vessel homicide, recklessness needs to be proven.
Only recklessness needs to be
Okay.
proven.
Right, okay. And that is in line with what would be the greater offense, manslaughter under culpable negligence, right?
So far, so good, I agree.
But if the jury does not find vessel homicide under only recklessness,
Yep.
okay, that line, why couldn't a jury still find manslaughter under intentional act?
Because intentional is even more serious than reckless and culpable negligence. It's intentional. It was an intentional act to strike the marker, not as a result of just driving culpably negligent or recklessly. So that's should be the absolute highest level of mens rea. It's like voluntary manslaughter as opposed to involuntary manslaughter. It makes no logical sense. It's not a possibility logically or legally that a court of appeals will sustain it and forgive the jury for acting illogically.
But intentionally committed an act or acts that caused the death. Again, I think is the difference in the intentional acts being the intentional act of speeding or going fast. The intentional act of
It has to be an intentional act that caused the death.
okay.
That's why we had this conversation 2 hours ago.
That's right, we
And
did.
now it all comes to a head
Yes.
because the state is resisting the reality of McCreary that, not reality, but the stated position of the Supreme Court of Florida, McCreary, that vessel homicide is a lesser included offense of the manslaughter charge.
But what I don't think is connecting right now is that the state is not relying on that as a lesser included. We've separately charged it so that the jury can make their own finding as to each count, as to each charge in the information.
Okay, so let me ask this. Could the defense, if they asked for a lesser under manslaughter, could they ask for a lesser of
Culpable negligence.
culpable negligence?
If they wanted to, as a category 2, have a lesser, yes. I just didn't hear them asking for a lesser
I
under
just,
instruction.
okay, all right.
I wouldn't have fight against that. If they want culpable negligence as a lesser of manslaughter, no problem.
Okay. But that would go back to the instruction that you had proposed as a special rather than a separate lesser crime.
Could you please repeat that? I'm sorry.
And it wouldn't apply because the lesser one isn't included when it's not to be used unless there's a death here, so it can't be a lesser.
But speaking of lessers, there is the original misdemeanor charge that was brought against Mr. Pino, that failure to abide by the navigation rules resulting in an accident or in a boat crash that causes death. We would submit particularly given now that the jury is hearing navigation rules, that lesser included offense be made available to Mr. Pino.
Okay.
Under manslaughter as a lesser? It's not a cat 1 or cat 2.
I think it would be.
It's not a lesser included of,
Vessel homicide.
isn't it a lesser included of vessel homicide? Did you check and see? Vessel homicide is 7.9, right?
I think it's characterized as a permissive lesser included.
No, it's not. It's not a statutory lesser. It's not.
Well, Judge, the statute is 327.33.
What's that? I'm sorry?
The statute is 327.33
Right.
under, which is listed here on this table, under reckless driving.
That's a separate charge though. It's not a lesser of vessel homicide, or the state didn't charge it. So it's not a lesser. It's not a lesser
No,
of
but-
vessel homicide.
No, but counsel's right, Judge. 327.33 is the statute that provides the misdemeanor that if a defendant violates a navigational rule without operating the vessel recklessly and death or serious bodily injury results, that is a violation of 327.
Well, that's what your special instruction is. Well, your special
No.
instruction talks about navigation. It's 327. Go ahead. Oh, I see what you're saying. Reckless operation of vehicle. Okay.
And under
28.19. As a category 2 lesser. 28.19. I don't think I've ever used this. Let's find it. 2819. Reckless. Okay. Do you want? Are you requesting that as a lesser?
I suppose we better confer with Mr. Pino about this, so we'll do that.
Oh yeah. Okay.
That makes things a little tricky, Judge, because, we need to be able to plan our closing arguments based on what the jury instructions were going to be, which
Yeah,
I
I
thought we
know.
would be
Okay.
able
We'll
to.
do it
So-
today. We'll do it now.
Okay.
If we take a break, we can do it.
Yeah.
No.
So I think I'm ready to take a break.
Perfect.
Oh, you go. Let's take a break.
Oh. If your court reporter has one more minute, Mr. Arbolino located where the court discussed the issue of instructing the jury on the personal flotation devices.
Uh-huh.
Yeah, if you want, I can play the video for you from court.
Sure.
Put it on the microphone, I guess. Are these on?
You just put. You want to just.
Or just so to make sure it's on. Okay. So this is from day 3 on Court TV on YouTube at 5 hours 11 minutes.
Okay.
Person. What is the law in Florida as to who must wear a personal flotation device?
Objection, counsel, legal conclusion.
If you don't.
Just say, instruct the jury.
minors under a certain weight?
That was from Sergeant Delgado. I'm not sure if that was also broached with Officer Albert, with Paul Albert.
And I think that was a different witness, right?
Correct, that was Sergeant Delgado, not
It
Paul
was.
Albert.
But the question was, what is the law in Florida as to personal flotation devices? And the court sustained an objection to that question and noted to the jury that it would be instructed.
I'm not going to instruct the jury because I'm not going to do that. I anticipated and knew actually also that that would come out through what's his name, Albert. So,
Okay.
glad you found it, but it wasn't intended at that point at all that I would instruct the jury, special, because I knew that was going to be coming up later on.
We'd still request it based on that.
Okay, that's fine. Thank you.
Thank you.
And if you find the portion of when Albert was testifying about it, and there were questions about it, then you'll find in the record that the jury did hear that it is not the law, and in fact there was more detail. Only a person under the age of
6.
whatever details he went into are required to wear a personal flotation device. So the jury heard it without objection through the witness, and so I don't need to instruct them specifically. Thank you. All right, so you're gonna let me know about 28.19?
Yes. Can we recess for
Yeah.
15 minutes?
Sure. Because we're pretty much finished with the instructions. At this point, I think other than whether, well, I need to know that, I need to have him on the Zoom basically to let me know about everything in terms of what we discussed on the instruction charge conference today, and specifically on the lesser.
Your Honor, the instruction 28.19
Yes,
is as to 327.33 subsection 1.
okay.
But the provision that they're talking about is 327.33 subsection 3.
Oh,
And so I don't think that there is a standard jury instruction for that offense. I mean, certainly we can craft one if the defense wants that as a lesser. But the
Oh, I see.
28.19 is reckless operation of a vessel, which is not the same as violating a navigational rule, but not operating recklessly, and a death or serious bodily injury results.
yeah, that's the only one that actually makes reference, but it's a different subsection of the statute. But again, if you craft one, and we'll review it, if your client wants that to be included as a category 2 lesser, I guess the question's going to be, I guess I'll consider that down the road. You know, what a potential punishment would be if a jury came back on a crafted lesser.
Well, it would be a second-degree misdemeanor. That particular subsection is a second-degree misdemeanor.
Okay, well, that's what it was originally charged as, right?
Yes, Your Honor.
Okay. Okay. Because it was you were charged under subsection 3.
Yes.
Okay.
3, I think.
3A.
3A is.
Okay. All right, go. Let's take a break. Thank you.
Thank you.